You ever wonder why someone can be legally allowed to live in the country but suddenly not allowed to work for a few weeks? That gap is not a glitch. It is the immigration system playing a weird game of red light, green light with your paycheck. Status and work authorization sound like the same thing, but they are actually cousins, not twins. You can have valid status and still not have permission to work, which is basically like being allowed inside the amusement park but told you cannot ride any rides yet. Think about someone on an F-1 student visa who just landed an H-1B job offer. There's this thing called Cap Gap, which is basically a bridge that keeps their work authorization alive so they do not have to quit in October and awkwardly wait around until October of the following year. Without Cap Gap, thousands of new hires would be sitting at home refreshing their email instead of showing up to their new cubicle. The government basically said, fine, we will build you a temporary bridge so the music does not stop the second your student visa clock runs out. Now flip over to someone adjusting status, meaning they are applying for a green card from inside the country. They usually need something called an employment authorization document, which is just a fancy plastic card that says, yes, you may in fact earn money here. Here is where people get tripped up. Having a pending green card case does not automatically mean you can work. You need that separate card in hand or an approved extension before your boss can legally pay you. That is why lawyers obsess over expiration dates like they are countdown clocks in a heist movie. Miss the renewal window and you could end up in a gap where your old card expired and your new one has not arrived, and suddenly payroll is asking uncomfortable questions. To fix that headache, there are automatic extension rules that let certain renewal applicants keep working for a stretch of extra months while the government catches up on paperwork. It is basically the system admitting, yeah, we are slow, so here is some grace period so your life does not implode because of our backlog. Then there is portability under a rule nicknamed AC-21. Which lets some green card applicants switch employers without starting the whole process over. Imagine building a sandcastle for years and then being told you can move to a new beach without the tide washing it all away. That is the kind of relief this rule provides. For H-1B workers changing companies, timing gets even more dramatic. A new employer can file a transfer petition and the worker can often start the new job once that petition is simply received, not even approved yet, which feels like starting a race before the starting gun even fires. But here's the plot twist nobody warns you about. If that first job ends before the new petition is filed, you can slip into a status gap, and status gaps are the villain origin story of a lot of immigration nightmares. Employers sometimes assume paperwork magically transfers like a subscription renewal, but immigration timing is way pickier than your streaming service autopay. One missed date and someone who was working legally yesterday is suddenly not authorized today through no fault of their own. This is exactly why timing strategy is not just legal trivia, it is the difference between a smooth job transition and a very stressful unpaid vacation. Good lawyers track these dates like overprotective parents tracking a teenager's curfew. The lesson here is not that the system is impossible, it is that the system is full of small bridges, some sturdy and some rickety, connecting one status to the next. Knowing which bridge applies to your situation and when it starts and ends is basically the whole game. So if any of this sounds like it applies to your job, your visa, or your green card timeline, do not just wing it and hope for the best. You want to learn more about how we can help you navigate all of this? Check out our links in the description.